Okay, good morning, everybody. Today is Thursday, May 14th, 2026, and welcome to today's regular meeting of the California Fair Political Practices Commission. Ms. Vo, will you please take roll?
Commissioner Brandt?
Here.
Commissioner Ortiz?
Here.
Commissioner Wilson?
Here.
Chair Silver?
Here. Before we move on to item number one, I want to address the recent network outage that affected several California state agencies, including the California Fair Political Practices Commission. During this outage, the public's ability to communicate with the FPPC and access our website and resources was severely diminished. The outage stemmed from a combination of failures within the network of a state internet service provider, or an ISP, which included a damaged fiber line and complications during their facility transition. Our IT team worked around the clock, including through the weekend, alongside California Department of Technology, CDT, to restore services as quickly as possible. I want to thank them for that work and their extraordinary effort in this situation. That said, having our website and network down during a critical point in the election cycle is unacceptable, and we recognize that. We're taking concrete steps in coordination with CDT to prevent a similar outage from ever happening again. These steps include moving our network to the CGEN system for continuous monitoring, securing a backup connection from a second ISP, a second provider, so that a single failure cannot take us offline, and transitioning away from our current provider as part of this process. These changes are already underway, consistent with best practices in this area and the advice that we've received from CDT and other experts, and we will continue to update the public as they progress. In the future, if you experience any issues as far as our website or our technology, we're going to encourage you to reach out to our IT team at Webmaster, so W-E-B and Master, M-A-S-T-E-R, at fppc.ca.gov. Also, if you want the most up-to-date updates related to IT or the FPPC in general, we recommend that you go to our contacts page and sign up for one of our listservs. So we have various different listservs where you can keep yourself apprised of updates related to the FPPC. So thank you for that. Why don't we move on to item number one, and that's going to be public comment for items not on today's agenda. Do we have any public comment for items not on today's agenda? Looks like we do. Sir, you can come up to the dais. Good morning.
Good morning. My name is Christopher Butner. I'm a resident of Calaveras County in the Mother Lode region. I'm increasingly appalled by the flagrant violations of California government code blatantly committed by officials in Calaveras County and neighboring Tuolumne County. Political corruption runs deep in California's rural counties, much as it does in the large suburban and urban counties. The critical difference being fewer eyes and ears on the rural counties. The local politics are generational. Deep familial and social connections provide protective cover for endemic malfeasance. My investigative colleague and I are responsible for FPPC cases against 4 of the 5 sitting Calaveras County District Supervisors and 1 of 5 sitting Tuolumne County District Supervisors. Additional sworn complaints are pending filing. I'll now cite 2 egregious Calaveras County examples without naming the district supervisors, specifically to avoid biasing the commissioners. In both instances, it has become evident that the FPPC would greatly benefit from augmented state financial resources to combat the corrosiveness these blatant violations of the Political Reform Act have on my community. In one instance, a sitting Calaveras County District Supervisor under FPPC Enforcement Division investigation due to my sworn complaint also remains under criminal investigation due to my sworn complaint with the Calaveras County Sheriff's Office for allegations of his fraudulent misrepresentation and misuse of public funds. This supervisor astoundingly appears in several emails in the Epstein files, released by the U.S. Department of Justice in January, having had direct contact with Jeffrey Epstein and his associates, representing business interests of his longtime friend and confidant Sarah Ferguson, the former Duchess of York, for whom he served by his own admission as her chief of staff for many years. In another instance, a former Calaveras County District Supervisor was adjudicated in 2024 by the Calaveras County Superior Court for having met the criteria for elder abuse by defrauding an elderly business partner. He's now seeking to reclaim his seat, lost in 2018, and has a reasonably good chance of doing so because the incumbent under FPPC Enforcement Division investigation due to my sworn complaint, and now having numerous FPPC Enforcement Division probable cause findings pending, faces disqualification from office if allegations of him living outside of his supervisory district are validated. These matters of grave concern regarding ethically challenged and unscrupulous individuals would have been invisible to the FPPC Enforcement Division without the eyes and ears of aware and conscientious citizens on the ground, such as myself and my colleague. It is imperative that these individuals do not assume nor retain public office, as that would be to a great detriment to our communities and democratic ideals. Thank you very much. My name's Christopher Butner.
Thank you for your comment, Mr. Butner. I really appreciate you coming in person to the commission today and sharing all that information with us. Thank you. We have additional public comment in the room. Good morning.
My own? Yes. Good morning, Commissioners and Chair. My name is Scott Fischler. I'm an independent investigative reporter. You just heard, excuse me, you just heard from one of my associates addressing his concerns of endemic political corruption in the rural county where he resides, Calaveras County. So I'm also very disturbed by the blatant disregard and disrespect for the Political Reform Act that's demonstrated by local elected officials and candidates for office in the core counties of the Mother Lode region, Calaveras, Tuolumne, Amador, Mariposa, but also elsewhere throughout the state. I will have a closing comment to make about Tuolumne County in a moment. First, though, as Mr. Butner did, I want to acknowledge and state my appreciation for the difficult work that the FPPC does and performs in service to the people of California, despite extreme pressures, a very difficult budgetary climate each fiscal year. That's what I want to speak of for a moment here. So, a letter of support to the FPPC that was co-authored by me and sent Mr. Butner's name yesterday to the Senate Budget Committee Subcommittee, Senate Budget Subcommittee number 4 on State Administration and General Government, and the Assembly Budget Subcommittee number 5 on State Administration, urges a $1 million budget augmentation for the FPPC for fiscal year 2026-27. Now, I know this is a substantial and seemingly unrealistic overreach, seeking approximately 5% increase for the FPPC's budget in the next fiscal year when there's a persistent downward pressure just to simply hold the line and not have your budget trimmed or decimated. The fact patterns that we individually and collectively document prove that these are dire times in local government, particularly in small rural counties where fifth-generation families possess a strong sense of political entitlement, and combined with the loss of local newspapers and government accountability reporting and coverage, that presents a significant problem. The combination fosters a toxic environment where corruption festers and thrives. So a well-funded and robust FPPC must hold the line against that corrosiveness and the threat to democratic ideals and values. As noted now, I'll close with a comment about Tuolumne County. I'll cite one example, again without naming specific district supervisor, having a sworn complaint against them 4 weeks ago, specifically to avoid biasing the chair and the commissioners. The district supervisor running for re-election repeatedly and blatantly violates Government Code Sections 3206, 8314, 84502, and 84504.2 by displaying illicit campaign signage, prominently featuring unauthorized use of uniformed
Mr.
law
Fischler, I
enforcement.
apologize for interrupting you.
Yes, sir.
You did acknowledge the potential for bias, and I want to make sure that's not an issue here. So while you're not
appreciate
naming
that.
the person's name, I think they may be
Fair enough.
identifiable by saying incumbent.
Very nice.
So if there's anything additional to provide to enforcement, that's what I would recommend. That's the avenue.
I will refrain from further comment on that. Thank you for
Greatly
calling that to my
appreciate it.
attention.
Thank you.
I'll close by saying more money for the FPPC equals more enforcement and education. And I thank you all for your time and your attention today. Very much appreciate what you all do. Thank you.
Well, thank you. We greatly appreciate you coming here in person. Ensuring that rural Californians and rural jurisdictions have the resources they need to comply, and then ultimately enforce these rules, and for us to enforce these rules in those jurisdictions is a priority for our agency. We've actually gone out to rural jurisdictions and met with officials in person. to get a better idea of what we can do to support all of you. So I really appreciate you coming out today and highlighting this important issue. Thank you. Do we have additional public comment in the room? We do. Go ahead. Good morning.
Thought it was on. Okay, now it's staying on. Okay, anyway, Mr. Silver, I'm sorry I'm a little late getting here. I wanted to give copies of what I was going to say today to the secretary for you, but instead of extending this on, I'm going to I'll just hit the highlights of what I wanted to say. It's my pleasure to address this body once again, and I'd like to thank your Executive Director, Galena West, and your Head of Enforcement, Kendall Bonebreak, for meeting with me to discuss my complaint and educate me as to the restraints put on this commission. I am of the opinion, backed by the facts, that the FPPC has been bureaucratically hamstrung either by their own volition or by the bureaucracy itself. Now, my complaint was about 1090, which is contracts that the elected officials might enter into. And it turns out that after I've gone through all of this, it turns out the FPPC can't handle the removal, or not the removal, but the disqualification of a person from office after they break this law. Instead of telling us in the code somewhere that there are two jurisdictions, one the DA to handle criminal and the other to handle the civil and administrative penalties, a member of the public comes up here uneducated and incapable of resolving the situation the way it should be. I'm going to make an appointment with my local DA, explain the situation to her. I have a 126-page document that the FPPC gave me. I have my response to that document and all the mistakes that were contained within it. But the DA actually does not have any of this material. And when your people submit to the DA and say, can we have permission to go after this person, the only thing they can say is, we don't have the information to do it ourselves. Well, my question is, why isn't the FPPC working with the local DAs to resolve this situation? There's been criminal activity here, and I'm going to pursue it to the full extent that I can, including going to the state attorney general. And I'd like the FPPC, your board, to tell me, what legislatures I should approach, or how I can strengthen this organization to where this isn't pass the buck kind of thing, or kick the can down the road, hopefully the public will go away. I think that's pretty much summarizes everything I have to say. I'm going to give the 5 copies I have here to Ms. West, and she can distribute it to you later, or I can give it to, I guess you say. All right, thank you very much.
Mr. Caramello, will you state your name, just for the record, into the microphone?
That's a large point of contention. The Brown Act states that I don't have to do that to identify myself to attend a meeting.
Yeah, it's
if
completely up to you. So would you like to state your name?
I usually don't.
That's fine then.
I go by pseudonyms such as Edmund Fitzgerald. But yes, my name is Michael Caramello. I'm a publisher, editor, and operator of the Dixon Informer online newspaper. And I guess that's it. Thank you.
Well, thank you for coming today. We appreciate you raising this issue and continuing to engage with the commission. Thank you. Do we have any other additional public comment in the room? Okay, hearing and seeing none. Do we have any additional public comment online? No? Okay, then why don't we move on to item number 2, and that's going to be approval of our March 2026 minutes. Do we have any comments or questions from commissioners on the minutes? Do we have any public comment on the minutes? No?
So
Okay.
motion to approve the March 2026 commission meeting minutes.
Second.
Okay, Ms. Vo?
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Okay, let's move on to our consent calendar, and that's going to be items 3 through 7. Are there any items on the consent calendar that commissioners would like to discuss or pull? Commissioner Ortiz? No? Oh, I saw this. I didn't know what this was. No? Okay. Do we have any public comment on the consent calendar? Okay, then I would move to approve the consent calendar, which is items 3 through 7.
I second.
Excellent. Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz,
Aye.
Commissioner Wilson,
Aye.
Chair Silver,
Aye.
motion passes.
Let's move on to item number 8. That's our pre-notice defaults. We're going to welcome our Chief Enforcement, Kendall Bonebrake, to the desk up here. Answer any questions that commissioners may have. So this is in the matter of Robert Scharfenberg. Good morning, Ms.
Good-
Bonebrake.
Good morning, Chair, Commissioners. This is our one pre-notice default on today's agenda. As we've discussed in the past, this is not a requirement of the law, but a last opportunity for the respondent in this matter to reach out to us. And so this is the pre-notice. The default will be on a future agenda, assuming we aren't able to connect with the respondent.
Excellent. Thank you for that additional background. Do we have any questions or comments from commissioners? No? Okay, we're not going to take any action on this item at this time. Thank you, Ms. Bonebrake. Let's move on to item number 9. And that's going to be our general items, starting with pre-notice discussion of proposed adoption of Regulation 18450.12 and amendments to Regulation 18401, AI use in campaign advertisement disclosure and related record keeping. We have our senior commission counsel, Zachary Norton, up here at the desk to walk us through this complicated regulation. Unfortunately for Mr. Norton, it seems like he has to walk us through every complicated regulation these days. So thank you, Mr. Norton, for your patience.
Thank you. So good morning, Chair Silver and Commissioners. So we have for pre-notice discussion, proposed regulation 18450.12 and amendments to existing regulation 18401. So today's proposal concerns 2 issues, both relating to campaign advertisements. So the first issue involves clarifying the circumstances under which a campaign advertisement is substantially altered using artificial intelligence, thus requiring disclosure under recently enacted Section 84514. And issue 2 being amending the record-keeping regulation to do 2 things. Make explicit the existing record-keeping requirements that apply to all committee advertisements, as well as requiring original versions of any materials used to create advertisements using AI. So let's begin with the first regulation, 18450.12, requiring artificial intelligence disclosure. And so for a little bit of background, we're talking about generative AI or Gen AI, which is a type of artificial intelligence that can generate synthetic content that includes text, video, and audio that's able to emulate the structure and characteristics of the training data used, which typically in this situation, we're looking at emulating the images of people. So generative AI has proved to be transformative in the realm of political ads and advertising generally. So campaigns are using generative AI for print, audio, and video ads, both to promote candidates and for hit pieces. And a recent survey from earlier this year indicates that 83% of ad executives now say that their company is using AI in the creative process. Oh, sorry. And that's up from 60% of ad execs in a 2024 study. So we're seeing a rapid increase in the use of this technology. And the Enforcement Division investigators have identified several instances in which it is unclear whether disclosure would be required under the statute. So a little bit about the statute. Section 84514 went into effect in 2025, and it requires disclaimer on campaign advertisements that are generated or substantially altered using artificial intelligence. I think the primary focus of the statutory language is to target what is commonly known as deep fakes or these sort of deceptive AI advertisements. I'll speak up.
Yeah, Mr. Norton, could you speak closer to the microphone?
Okay. Make sure my volume's okay, so I don't. Okay, that sounds good. All right. So the statute itself requires a threshold inquiry as to whether an advertisement fits within the definition of qualified political advertisement. That being any advertisement that is generated or substantially altered using AI. So if AI has not been used in any way to create the advertisement, this doesn't apply and there's no analysis. And if AI has been used, then it must be determined whether each of the two prongs of the statute are met. So the statute specifically requires for if an advertisement is entirely created using AI and would falsely appear to a reasonable person to be authentic, it would require disclosure. We think that this creates a fairly bright line test. The other prong being if it is substantially altered, would this alteration cause a reasonable person to have a fundamentally different understanding of the altered media when compared to an unaltered version? So,
Commissioner Brandt?
So I want to dig a little bit on that one. I want to understand what
Yes.
the legislature did because I'm, so I work in the judicial branch and there's a lot of discussion. I lead an AI initiative at the National Judicial College. There's a lot of discussion about disclosure and when it's required and all those kinds of things. And the courts are all over the map. I'm trying to understand what your understanding is of the reason the legislature, are the two things required? Are two, item 2 and item 3, they're both required, and I perhaps see that, but did they intend that, or did they intend to have disclosure of anything that's artificially AI generated? In other words, what do the legislative analysis say about this? In other words, did they require both that it's artificially created and that there creates confusion? It requires both?
I believe so. Now, there's not a great deal in the administrative record, although just looking at the statute, the way the statute is structured is interesting. It talks about qualified political advertisements at the outset and then doesn't define qualified political advertisement until the very end. And that a qualified political advertisement under the statute is any advertisement that contains any image, audio, or video that is generated or substantially altered using artificial intelligence.
Right.
So I think if the statute simply sort of left it at that, saying if it's a qualified political advertisement per this definition, there must be disclosure. I think what the statute does is it then introduces this sort of two-factor test saying, here's under either of these circumstances, it does require disclosure. So I think it requires a more nuanced analysis. It's not just if you have any AI, you have disclosure. The AI has to be used in a certain way to meet one of the two thresholds in order to trigger the disclosure requirement. So that it would rule out probably very minor uses of AI.
Okay. That minor uses, I don't see that, the language. And so that's what I'm trying to understand. What about substantial uses? The whole thing was created, but it doesn't meet one of the other requirements. So there's no disclosure required for that one. That's what I'm trying to understand your basis if you're coming to that conclusion. In other words, the whole thing was created by AI. We have no idea, all these images, all things created by AI. But if it's not deceptive or doesn't meet one of the two prongs, then there's no disclosure required. Is that what you're telling me?
Mr. Norton, quick question for you that I think will address Commissioner Brandt's question here. we have slides that you can walk us through that demonstrate this analysis as to an actual advertisement. Right?
Yes, yes, we do.
And, one of my concerns, priorities, however you want to phrase it, with this regulation and the amended regulation is that we make it very clear for the regulated community and for enforcement and for the public as to what triggers the disclaimer and what doesn't. So I think it is worth,
Yes.
per Commissioner Brandt's line of questioning, that we walk through this test very deliberately and thoughtfully so everybody understands where we're coming from, right? Because this is a very complex topic, and the statute isn't, as clear as perhaps we'd hope it would be. So it looks like you have this threshold inquiry where we're looking at whether an advertisement meets the definition of qualified political advertisement in Government Code Section 84514, D3,
Yes.
correct? And
Yes.
that is where we look to see whether an advertisement contains any image, audio, or video that's generated or substantially altered using artificial intelligence.
Correct.
As you laid out, basically, was the publisher of this ad, the developer, whoever prepared it, use AI in any way, right, for this threshold inquiry?
Yes.
Then we're going to move on to these two additional prongs, which look at the entire advertisement as a whole.
Yes.
And we separate those prongs. We decide which one of those prongs apply, which one of those tests are going to apply based on whether the entire advertisement was created with AI as defined here, right? Or it was simply modified using AI. Is that correct?
Yes, that's correct.
Okay. So in order for this disclaimer to be triggered, it's not that any form of AI, such as, spell check or some of the basic exemptions that are actually provided in the statute, such as like immaterially altered changes like cosmetic adjustments. If that use of AI is the only use of AI, that is not going to trigger the disclaimer unless there's some additional element that satisfies one of these two prongs. Is that correct?
That's correct. Yes. And I think that sort of carve out within the statute, I think that is meant to kind of address the traditional work that might have been done with Photoshop or something. If you're just adjusting the color or taking a glare away or something like that, that is not what we're talking about in terms of AI disclosure. And
But I understand that. And so
Yes.
my point is, it's a qualified, it meets the qualified definition.
yes, it
In
does.
other words, no, right. I'm giving you perhaps a hypothetical.
Okay.
So one that meets a qualified, but it's not deceptive, or it's not D2 A and B. It doesn't meet those things. So you're telling me if it doesn't meet those things, then even though it's qualified advertisement, there's no disclosure. Am I getting that right?
Yes, that's how we're reading it. Because I think if we otherwise just said if it's a qualified political advertisement, it requires disclosure, it sort of reads those two factors out of the statute, because then you would qualified political advertisement is defined right at the end. Maybe
Right.
that's not very helpful, but that kind of is our starting point. And if we left it at that, it would encompass, I think, way too much, and then you wouldn't really look at those factors.
Okay, and
I
so
think-
when you say way too much, so a qualified, and I'm not talking about Photoshop or minor changes or spell check. I'm talking about something that was completely created. The images are all fake. They're
Yes.
all fake, but they may not meet the thing. So that doesn't,
Well-
and that's part of this is I'm also thinking about long-term, thinking about whether we need to have those kinds of notices. I mean, there's a lot of debate in the judiciary about writing, and how much it's doing, and there's a lot of different ways, and there's a lot of disclosure requirements that, if any of it, and then they say, 50%, all those kinds of
Yes.
things. And I'm just thinking whether should the statute be broader, and I'm perhaps willing to just let's start here. This is what the statute says, but I'm wondering and I guess let's see how many actually disclose. How many actually show up as disclosing AI? Because I'm concerned that it's not deceptive, but it looks like makes the person look really amazing. that kind of thing. I mean, it's a positive. It's not, and it's not deceptive because it's within range of, it's more or less accurate, but it's like, I don't know. And that's why I'm just trying to figure out what we do here. So I've read the memo and I get it. I just want to understand, and I think I heard from you, it's like it writes out those. If we don't require those as well, D2, then we write those out of the statute. Okay.
Yes.
Okay. Thank you. I think that answers my question. So I think I'm good for now, although, yeah. Okay.
And
sorry.
Commissioner Ortiz, just a quick note from General Counsel Bainbridge.
Yeah, I just wanted a point of clarification. If it is entirely created using AI, it's going to fall under D2A little I. If it's partially created using AI, it's going to fall under D1 or D2A 2 little i's. So there's two different standards depending on whether it's entirely created using AI or partially created. So I just wanted to make that point of clarification.
Commissioner Ortiz?
Yes, all this discussion and reading this memo reminds me of the confusion that exists with mailers by local entities that cross the line about what pay with public money and the whole thing. I think this is going to have to be clear so that we don't get into like the local agency sending mailers with public money at public expense. And there are words or terms that makes me have that concern. For example, substantially altered. What is substantially? Who's going to determine that?
Yes, I see your point, and we do recognize that.
Yeah.
It is not entirely clear, and it may. We're hoping to try to bring a little bit more clarity to this because it's so new. I think in terms of public compliance, I think we would presumably do a fact sheet on this as well, because I think helping the public understand exactly how this would apply is important so that we have proper disclosure. And I think there's also the potential concern for over-disclosure. If we have AI disclosures on virtually every advertising piece because AI is becoming ubiquitous, it becomes almost like the Prop 65 disclosure that you see everywhere. So that something here may cause cancer. You don't really know what it is. You see the sign. Over-disclosure that might blur the issue where you want disclosure on the sort of deepfake Gen AI. What you don't want disclosure on is, if I'm the candidate, we did a little Photoshop to clean up the image and there's nothing and there's disclosure there. People start to think, everything has a disclosure. It doesn't mean anything, and it doesn't really signal when it's a deepfake versus when it's just a cosmetic, something minor.
Commissioner Wilson, or Commissioner Ortiz,
Yeah,
did I
and
interrupt you?
I don't want to lessen the importance of this.
Yeah, oh,
This
yes.
is really important. We're seeing some examples already out there. So this is very important, but we need to be somehow making the lines not so gray, but really clear. Because this is up for interpretation, whoever wants to fight it or whatever. Yeah,
Yes.
thank you.
Commissioner Wilson?
Council Norton, thank you for the presentation. Just a kind of quick question for some clarification in terms of how we potentially move forward. Have we, in light of the passage of this, number of bills and the court's involvement on a certain level, I'm assuming that whatever we do, we'll do in court-specific coordination with at least legislative staff, so we get clarification on what was the intent of the legislation. How have judicial rulings impacted what we're trying to do? Because what a reasonable person might see may differ from what the actual intent is. So I'm just curious, how we plan to implement regulations and at the same time coordinate, with the authors of legislation and possibly, look at, what the best options are.
Yes, and I did reach out to staff. I think their position was, they felt that the statute was clear enough on its face. I didn't get any specific feedback as to the proposed regulatory language. And we have been following, there's the two other sort of complementary pieces of legislation that were both overturned in courts and one is on appeal. We're following those. Ours has not been challenged, the statute that we're looking at. So we're assuming at this point that we are on solid legal ground moving forward.
Right,
Yes.
despite the court's rulings.
Yes, well, and ours is much narrower, so I think we have that distinction that this is the disclaimer that applies to political advertisements. So I think the concerns that it, would encompass unpaid speech, satire, something like that, those seem to be absent here.
I was going to ask you about satire, if you could comment on how these regulations and the legislation potentially impacts, an ad, a political ad that is clearly satire, where it portrays an elected official as someone who, they clearly aren't.
Yeah, that's, that may be open for interpretation. I think our position now is if it's an advertisement and it's produced by the candidate or committee, it likely would require this disclosure. And I think there might be a difference here. If it's an advertisement produced by a candidate committee, is it satire or is it an advertisement that's being done to promote a candidacy or the adoption or rejection of a particular measure? I think that might be a significant distinction between something that's purely satire and something that's actually an advertisement for purposes of the act.
Thank you.
And just to clarify, which staff did we speak with? Was it the initial author who introduced the bill, or was it one of the co-authors?
It was.
Was it Assembly member Wendy Carrillo, former Assembly member? Wendy
No, it was
Carrillo
not the
staff?
former Assembly member. It was.
Assembly member, or former Assembly member Sabrina Cervantes, who's now in the Senate?
No, these were two current staff members that were involved in.
So committee staff?
Yeah, committee staff. I did reach out to Ms. Nakano and ask if she had a contact, and I received contact for two staff members. They were very familiar with it. They said they felt the language was clear, so.
And that was for both houses? Well, I'd just recommend, let's go back, take a look at the notes, and if we haven't confirmed with both houses, we certainly should.
Yeah.
I was going to touch on this later on after we ran through the examples, but I think it's worth noting at this point, as to the comments that Commissioner Ortiz made here. I think it's critical that we engage with the regulated community stakeholders on this in terms of the practical implications and the possibility for potential loopholes for bad actors. The reality is, while we're experts on the Political Reform Act, we're not necessarily experts on producing mail or video advertisements, et cetera. So I think it's very important that we reach out, and it's very important that they reach out to us and provide us with the sort of hypotheticals, questions that we're likely going to see after this regulation is adopted and amended. And I think that would be the time we would not want to have to deal with all these potential issues related to this requirement. We really want to flush these things out now rather than later. So I think it's especially critical that we do that because we're in the middle of an election, and folks want to be able to understand how to apply this new requirement. So, whatever normal protocols we go through to solicit that comment and feedback, we definitely want to do that here. I also like to disclose ex parte communications on my part, recognizing the complexity of this issue and its practical implications. I reached out to campaign consultants from both sides of the aisle. I reached out to Bill Wong, Jacob Bytel, and Kevin Reikus, who are campaign consultants, and I spoke to them about our proposed regulation and amendments to regulation. I also reached out to other campaign consultants who I wasn't able to have meetings with. And that's Dwayne DeCharia and Matt Rexroad, but I'm hoping to connect with them and get feedback on this. They agree as to the potential impact this could have, the practical impact, and they're planning to provide us with feedback as to how that we can pursue a regulation that avoids the types of unnecessary burden as well as potential loopholes that I'm concerned about, while still providing the public with the level of transparency that I think they deserve in this context. Commissioner Brandt?
So I think that may actually take it. So part of it today is I'm identifying the issues that I see that I'd like kind of further further, what does the community do? How does this work? So going to the point that General Counsel pointed about, 2A little I, completely created by artificial intelligence. And then the question is, and this is the statute, so I'm just trying to, and I perhaps this works, that would falsely appear to a reasonable person to be authentic. And so, so I guess that means if you do a satire and it's like obviously AI and this is not that person, he's in a clown suit or whatever, then you don't have to disclose because that's presumably that's what would not appear to anybody to be authentic. But if you do it where you created it completely by AI and it looks really positive, or it puts the opponent in a really, it looks reasonable, it looks to a reasonable person, it looks authentic, but it really is wrong. I mean, it's wrong. And perhaps then that goes to, well, not really, materially altered by artificial intelligence. So perhaps that goes to little two. So I'm just trying to understand, and that's where I think these conversations with the regulated community would help me understand. When are we, perhaps the question is, when are the times that you're not going to disclose? Because it's not, it's not authentic. And what is that, how is the difficulty? And I think that you're right. And I think this is going to evolve so quickly. I just don't know what we're going to do. And so I think maybe this is a good place to start with the regulations.
Well, I'm open to whatever approach other commissioners want to take, whether it's, posing more questions, comments to Council Norton, or taking a look at these examples, and he can walk us through his analysis. So I'd go with the latter approach. So I'm gonna ask them.
I'd say let's go forward.
Objection to that? Go ahead, Mr. Norton.
Okay. So would you like me just to walk through the examples and then explain it?
That would be great, unless you have any additional context that you want to provide before we delve into the examples.
At this point, no, I think we can just go with the examples.
Excellent, thank you.
Okay, so our first example is a campaign mailer. And for purposes of the example, we are going to assume that this was created in part with the use of AI. So we don't know that. We're just going to assume that it's a genuine photograph of the candidate and that AI was used to help create a background. So to add a photo and text images. So it would be a qualified political advertisement as part of the first step because it contains an image that is altered or created using artificial intelligence. And looking at it here, we would then examine whether the alteration would cause a reasonable person to have a fundamentally different understanding of the unaltered media when it is compared to the unaltered version. So here, the answer would be no. It's just using AI to add some background image for the mailer. It's probably no different than something that would have been done with Photoshop. It does not cause any fundamentally different understanding compared to the unaltered version.
And we would specifically be looking to the proposed regulatory language, though, correct? We would be looking as to whether the material alteration would cause a reasonable person to have a fundamentally different understanding of the altered media when it depicts. So I guess what I'm saying here is we'd be looking to see whether it depicts an individual saying or doing something the individual did not say or do, or contains a realistic depiction of something that did not occur.
Yes.
And what you're saying is that this does not meet that standard, and as a result, the disclaimer would not be required.
That's correct, yes.
Okay. Commissioner Wilson?
So this is a good example, I think, to lead me to the question that I was going to ask. It looks like City Hall in the background. And even if it was, let's say, photoshopped or altered, it would reasonably depict what this candidate is pursuing in terms of elected office. But what if in the background it was Buckingham Palace? And you know that, well, okay, this person can't be running for an office in another country. How would that come into play in terms of the whole standard of altered media?
Or perhaps the legislative building was on fire. So both those examples, I think, would be illustrative.
Well, I think you would then you'd look at both. Does it create a fundamentally different understanding, or does it depict something that did not occur? I think both of those standards would then become relevant. Yeah, well, and that's the problem. I think it's, as the Supreme Court said about determining obscenity, is you know it when you see it, because when they were working on those. And I think part of this is we are trying to interpret a statute and draft a regulation that covers almost an infinite spectrum of video and photographic media that might be used. As to the building being on fire or Buckingham Palace, it might depend on how realistic the image is. If it's trying to suggest that this person actually visited Buckingham Palace for some reason, I think that's different than just, this is just sort of a general photographic representation of, this is the candidate I'm seeking office to serve in the legislature, and here's a picture of the building. So it's not suggesting that she's actually a member or that she's an incumbent. It's just a sort of.
Sure, and we're looking at more than just, is this advertisement a realistic depiction, right? Is it realistic? Does it look
Yes.
authentic? We're also looking to see whether it's a realistic depiction of something that did not occur.
Exactly.
So
yes.
essentially, if the Capitol
Yes.
building is on fire
Yes.
and we know that it was not on fire,
Yes. I think that probably gets you there.
right? Moreover, if we're confident as an enforcement division that you didn't have Miss Goldoni, my apologies if she's a real person and I mispronounced
She is.
that.
It is a real, yeah.
If she was not in the legislature when the building was burning, there's all sorts of different things
Yeah.
to consider here. One question I have is, so we're looking at this ad. We're saying that the part of this ad that is not AI generated for purposes of our discussion is this photo of Miss Goldoni, right?
Yes.
The rest of it's generated with AI for purposes of our discussion. So let's say we take Miss Goldoni out and it's just this ad that was created with AI. So would that trigger a disclaimer? Because that would, I would assume we would apply the first prong in that circumstance, right? Because the entire advertisement
Yes.
would be generated with AI.
Yes.
So I'm concerned that, like you mentioned with the warnings that we often see at Starbucks, different restaurants, stores, etc., that what's going to end up happening under the current language is we're going to see widespread disclaimers of AI use and modification in campaign advertisements. And it's either going to lose its impact or effect, intended effect on the public, right? They're just going to assume every single campaign advertisement is created with AI, or we're automatically going to, it could potentially be both, we're going to influence the public through this as to their viewpoint on specific advertisements. One of the folks that I spoke with pointed me to a survey that was taken by a group of campaign consultants related to AI disclaimers. And their survey showed that folks that were looking at these advertisements, as soon as they saw an AI disclaimer, they became immediately more skeptical of the disclaimer. So basically their viewpoint of this disclaimer, of this advertisement as a whole, is going to be impacted potentially by having that disclaimer in there. And if we're just talking about an image of the Capitol building with a legislator's name, for example, having that on there, that concerns me as to whether it's consistent with the intent of this bill, right? Which you laid out, which is what we interpret as addressing deepfakes,
Yes.
misrepresentations, deceptive towards the sorts of advertisements. So I say all that in hopes that we can identify a potential option moving forward that makes the scope of this requirement consistent to the extent we can within the language of this statute between advertisements that are entirely generated with AI and advertisements that are modified with AI. And the reason for that is I don't necessarily see a policy purpose for creating a difference in terms of this disclaimer requirement for an ad that is entirely created with AI versus one that's modified, like that example I just walked you through where we remove Ms. Goldini. But that said, I understand, we can't amend statutes. We're here to interpret the law. So if the reality is we don't have that sort of discretion, we don't have that sort of discretion. But I'm hoping that when we come back in August, that we have a potential option, to the extent there is one, from legal that would allow us to create that consistency between the two-prong tests. General Counsel Bainbridge?
Yeah, I just wanted to say, I think what we're talking about here is defining the term authentic when I look at it. I mean, there's two different standards here with different language, so we can't treat them the same under reasonable interpretation of statutes. They say, the legislature said different things, so they have to mean different things when they say different things. But I think where we have some room would be in interpreting what authentic means in this section. So I think we'll explore that. What would be helpful for us today is for the commissioners to weigh in on what they think should or shouldn't have a disclaimer as we go through these ads. And if you want to give hypotheticals and say how you think the law should be applied in those situations, that would really help us in drafting a definition. Because we have some room here to define the term authentic, and we have some room to define what fundamentally different understanding means. So if we know where the commission is on that, we can use your feelings on that to draft definitions of those terms.
Well, I guess I'll start with that. I would say, as far as I'm concerned, to the extent it would be possible, I don't think a disclaimer should be required. I don't think it's beneficial to the public to have a disclaimer in this ad as is, right?
Yes.
Just based on the fact that they added a picture of the Capitol building behind this candidate. I also don't think it would be beneficial to the public and consistent with the intent here to add a disclaimer if you just have a photo that realistically depicts the Capitol building, right? So that's my take. Commissioner Ortiz?
Thank you. When you were talking, at some point you mentioned entirely created by AI. And then we have another one is substantially altered. So is that A and B? I'm trying to get those two terms,
Yes.
to understand those two terms.
And that's, the statute itself sets up these sort of two different tests with, you've got one standard for something entirely created, and then you have a slightly different standard for something that's substantially altered.
And are the requirements then only for substantially altered or for entirely created?
And that goes back to what General Counsel Bainbridge was just saying, that if it's entirely created, needs to be falsely appear to a reasonable person to be
Okay,
authentic.
if it's, but it says substantially altered also goes
Yes.
to the second part.
That goes to the second, yes.
The rational
Yeah.
person thing. So, again, if it's like, if this thing was entirely created by AI, it doesn't kick in the reporting requirement. What it kicks in is the substantially altered.
No, if it's entirely created and falsely appears to be authentic, it would trigger the disclosure requirements. So that's kind of the issue. And that is the issue that Chair Silver referenced. Well, what if it's entirely created, but it's just the Capitol building and it says, vote for her? It's entirely created. Should it have disclaimer
So essentially
language?
what you're saying is there's two tests for an advertisement that was
That's what I
created
was
with
getting
AI.
at.
Yes.
Yeah.
Yes.
So there's two tests. You got the first test for an advertisement that was entirely created with AI. So I told ChatGPT or
Yeah.
Google or whomever, I want you to create me an advertisement for Jess Goldoni that states her name and the position she's running for in front of the Capitol building, and it creates it.
Yeah.
So that would be subject, we would look at the first prong, that first.
So
test.
that's what I'm trying to get. Yeah,
So that, we'd look at that first test to see whether the disclaimer
the
is triggered.
entirety.
Right, but here, because this image was created, right, we had this initial advertisement, and we added a real photo in there, not using AI, so
Yeah.
it's materially, altered. In that circumstance, we'd be looking at this definition that we're proposing in the regulation, right? So when you're talking about materially altered, substantially altered, ultimately, what we're looking at is, would it cause a reasonable person to have a fundamentally different understanding of the altered media? And we further define that as saying it depicts an individual saying or doing something the individual did not say or do, right? Or contains a realistic depiction of something that did not occur.
So that's
So-
the second prong.
That's the
Yes,
second.
it's
Yes.
the second prong. And so what happens? I am a campaign manager and I'm doing his campaign and I go, okay, I'm going to create the whole thing with AI. And I don't disclose. Who is it? Somebody who files a complaint that comes to the attention of the FPPC? How is that going to function?
It could be, yes. I think sometimes there's proactive efforts. Mostly it's someone files a complaint. They see an advertisement on television or receive a mailer. It doesn't have proper disclaimer. Typically now it's paid for by disclaimer that we get complaints on. They file a complaint, enforcement opens up a case.
So you will be relying on complaints in many ways, because this is such a complicated policy that if I'm a person and I hate you, I'm going to go and file something claiming, see, it's
Yeah, and then how
It's-
do we figure out
yeah,
whether the ad
yeah,
was modified
yeah.
or completely generated?
And
Hi.
that's a genuine
Completely
concern.
different issue in a sense, and that's something that we're working with our IT team to create a process for determining. We're looking at taking a 3-prong test. I'm not gonna get too far into it because I don't want to take us off the
Yeah.
discussion. But you have that piece. But this regulation that we're looking at, the amendments relate to that as well, because we're trying to create a process that allows for the enforcement division to evaluate those sorts of complaints.
yeah. That's gonna
Because
be
right
very
now, under the
important.
current record-keeping requirements, it's gonna be difficult for the enforcement division to make these sort of evaluations, at least to the ones that are materially
Yes.
altered.
And I think that goes to the idea that ads like our first example here, there's the fact that we're assuming AI was used, that makes it novel, but this is really no different than an ad you might have seen 20 years ago, 50 years ago, using either Photoshop or just some sort of, cutting and pasting negatives, let's overlay the picture, the technique isn't really any different.
Commissioner Wilson?
Yeah, and I think you make an excellent point in terms of how it was, let's say, 10, 15 years ago. But here you have artificial intelligence, and then you also have social media. So if you have an ad that is clearly deceptive, and a so-called reasonable person would realize if they're watching a network station and they see an ad, that's unreasonable.
Yes.
But if I'm someone who spends the majority of my time watching social media, and I look at this ad, and I think, oh,
Yes.
I believe this ad. Am I still going to be the reasonable person that when I see it on television, I'm going to think, oh, this is clearly altered media? Say, I think what's on TV is false. I think it's not accurate. But what I saw on Threads or one of those, or Instagram,
yes.
I believe that's in fact reality. So it's very, as Commissioner Ortiz, I think, pointed out, it's very complex. And I'm sure the chair and executive director have thought about this. We also need to make sure that the FPPC has the staff resources
Yep.
to be able to address these issues, because you guys already work hard enough as it is, and additional responsibility requires additional staff resources.
I second that
Very
part.
true.
So, General Counsel Bainbridge essentially is asking for us to provide direction as to where we think a disclaimer is required. We're is not necessarily required, right? I think by reading your memo, laying out the three different bills that went through the legislature, that the governor signed, two of which were ultimately struck down, it sounds like the purpose of those bills as a package was to address misrepresentation, deception through deepfakes, correct?
Yes.
It wasn't merely that, artificial intelligence, whether it's spell check or Grammarly or ChatGPT, it's evil or bad and by its nature deceptive. So the public needs to know whenever this is used. That's my impression. So I think what we're looking at here is we're trying to identify for the public when someone is using artificial intelligence tools, advanced artificial intelligence tools to portray something that did not happen, something that was not said, someone saying something that was not said, somebody doing something that was not done. And I think that, for me at least, that is where I would like us to go to the extent that we can within this language. Commissioner Brandt?
So I really appreciate this discussion, and I'm perhaps in a little bit different place for you. Yes, I think we should focus on prong II, and that's really what we need to focus on, because that's what the legislature. But the only bill that's survived is this statute. So I think that General Counsel Bainbridge made a good point. We're stuck with this language. So I think we can't say it's all created by AI, and this is the picture of the building, and they've just created it by AI. I think they're gonna have to require that they disclose that, because it looks like the building. It looks to a reasonable person like the authentic picture of the legislature. So, because what I think that does is that tells people, don't just use AI because you're lazy. In other words, go get a photo. There's plenty of photos on the internet of the Capitol building. So I think we need to, because of little I think we have to require disclosure, because that's what the statute says. And I think that may change over time, but I think this is where we need to go. We're going to require more disclosure than perhaps is necessary, but that's what the statute is at this point. So I think.
And just to be clear, this legislation, this law has not been challenged in court.
Right. That's what I'm saying. That's
Other
why.
disclaimer requirements have been challenged for AI and have been struck down. One of which did not apply solely to political committees and political actors like we're talking about here, but a district court struck it down. I think General Counsel Bainbridge could speak to it in further depth, but it was a general disclaimer requirement on AI-generated content. It included satire, and it was subsequently struck down by the court. So I think that's just one thing to also consider here.
Right, but satire and those kinds of things, that's not going to appear authentic, right?
Not necessarily, right? I could think of examples where someone could include images, video, content that is satirical to some, but to others it appears authentic.
So then I think we address that in the regulations by acknowledging, in the background, acknowledging the court's decision and saying this would not include satire, and we can make some object, because satire does not appear authentic. The purpose, the intent is to be satire.
Misleading, yeah.
Yeah, it's not intended to be misleading. It's
Yeah.
intended to be satire. And so that's why, and I'm not sure exactly how you do that, but I think that there is something. We have the language. If it looks authentic, then they need to disclose it, and I think that's how we get around the decision about, well, what about satire? Because I think then and maybe we need to do something with the regulation about drawing the line and what is satire. I'm not sure. Let's not go there. I'm not sure exactly how to do this. I mean, you're good lawyers. We don't be the lawyers, but I think my purpose is we need to follow the statute as it's written. If it comes out and there's problems down the road, then we can deal with that. But I think that we do our best to follow the statute, and maybe there is more disclosure than we need. But that's kind of what the statute says, and dealing with those cases somehow to acknowledge, well, satire doesn't, is not intended to look, and so it does not appear to reason. I don't know how you do this, but yeah, that's the
And
challenge.
Commissioner Brandt, I guess, I completely see where you're coming from, and I agree. We should act within our authority and act within what the statute tells us to do. With that said, I think we should acknowledge that if we take a broader approach to this regulation interpreting that statute, it's going to be more difficult for us to enforce. It's going to be more difficult for the regulated community to comply with. There's a lot of potential issues with that. So unless it's clear that that's the case and the legislative intent is saying, we want this to be a broad requirement, not only where there's misrepresentation. If anybody's using AI, even if it's to create a Capitol building, which exists and there's no
Nebraska.
misrepresentation there at all, or intended deception, we want this disclaimer because we think AI is bad or nefarious or could lead to, by its nature, deception, then I'm fine with that. But that's not how I see the intent. I don't think that was the intent of these three pieces of legislation. I think the intent was to ensure that the public is educated as to whether they're viewing something that is a misrepresentation of truth, not whether they're viewing something that was created with a specific tool.
I don't think we can go to those other statutes and because they've been struck down. We've got this one. This is the only one there. And I think we start with, the principle of how you apply legislation is you look, is there an understanding of what the word authentic means? And we can't say, oh, well, but there's all these other statutes. We just need to start there. We can't look at legislative history until we determine that there's no understanding of what authentic is. And that's an ambiguous term. And so we need to go to that. But, and perhaps I would say that's a hard thing to get over, to say there's no understanding, and the word authentic is ambiguous. So I think that's a hard thing. So I think we need to live with the statute at this point. And I don't think we can take in, they're trying to get to, with all these other statutes that were struck down, we're trying to get to misrepresentations. They chose this language, and that's where we need to start. So I think, so you have a challenge ahead of you to do this, because I respect that kind of comment, and that's why I want to hear from the regulated community about, I think in some ways, making a clear line about authentic, if it looks authentic, then you're going to have to disclose. And then your people, voters you're trying to get to, are going to say, oh, it's by AI. Oh, well, what's wrong with this? What's, that kind of thing. And so they're going to probably go to say, you know what, I'd rather use an official so I don't have a photo of the Capitol. I'm just going to use that and not use AI. Because the other piece I've seen is sometimes people are just lazy. Oh, it's easier to just have AI do this, and so there needs to be a cost of taking that kind of approach. And you're going to have to disclose that then. If you want to be lazy, it'd be easier for you to take a real photo and just add it. So anyway.
And I think that's consistent with
Commissioner Wilson? Well, go ahead, Mr.
Well, I'd say, just to Commissioner Brandt's comment, I think that is consistent with research on general public preference. I found a study that talks about the public feels that about 70% of the public feels that if AI is used in medical, pharmaceutical, financial services, or political advertisements, there should be disclosure, because they feel that is, in those situations, the use of AI should be disclosed.
Commissioner Wilson?
I think Commissioner Brandt raised a good point in terms of this ambiguity in terms of definition of authentic.
Yes.
And I'm a little, not concerned, but I think it's an issue worth looking at when you talk to staff. We don't mention their specific names, obviously, and staff says, well, the language is really clear. Okay, well, that's a convenient response, but if the language is really that clear, then one of the options we might want to consider is going back to the author or through staff and saying, well, since Legislative Council drafted the bill for your member and for your committee, can we get an opinion? It's not necessarily binding from Legislative Council on what was intended by the use of the term authentic. And I don't know if that's a reasonable request, but that's been done, over the years, because I think Commissioner Brandt's point is authentic is not clearly defined. And I don't think we're in a position at this commission to define authentic without further input.
Commissioner Ortiz?
Thank you. I don't know if I misunderstood Commissioner Brandt when you were talking about implementing the legislation, which I think you said it says in its entirety, correct? So regardless whether it's substantial alter or not, it is the entire thing being created by AI, regardless of how. Is that
Yes,
that what you
right.
were
So
saying?
that's little I. If it's
Yeah.
entirely created by AI, and it may look authentic, you're gonna need to disclose.
Yeah.
And I think
So that's the entirety, that's the
Right.
word, because that's what I've been struggling with, substantial and all that stuff. The other thing that I would like to see is, and I don't know if we're gonna see examples. So not only for us, but for the public, is where you say, this doesn't qualify. But if we go with Commissioner Brown, then everything, so who cares about the examples?
Well, but that's only if it's completely created by AI.
Yeah,
That's the
yeah.
difference. And that's where, and it's images, so it's qualified, has to be the images, not a language, it's not, what you say, it is the images. And and Commissioner Wilson, I think it's a hard case to make that authentic is not, that it's not clear to what that means for us. I think in some ways our job is to implement it, and I don't think I find it hard to say what are the two versions of what authentic is. And I think we implement it as is, and then we go, if they don't like it, or if there's problems with it, and then that needs to go back to the legislation. Because I think it's hard. I think it's a hard thing to say authentic. There's no common understanding of what authentic is. Can you help me, General Counsel Bainbridge, on what is the term? Is it common understanding? What's the word in the standard for when you go to legislative history? Common understanding, right. So I think it's hard to argue that there's not a common understanding of what authentic is.
I'd respectfully disagree in this context as to what authentic means in the context of AI, especially AI and campaign ads. Like, for example, we're looking at this ad, right? If this was blurred out, if it was an AI created photo, but it was blurred and clearly not the building, right? Because they used a poor AI software. Is that authentic? Does that look authentic? I would think it would depend on who you're asking, right? And I think regardless of what our opinions are on the definition of authentic, I don't think there's any downside to pursuing, the type of avenue that Commissioner Wilson pointed out in terms of getting further legislative history, especially when we're in a situation here where we really have very little legislative history. I see what you're saying. I think this is a valid argument with colorful arguments on both sides, and that's why
I'm willing to go the direction that you all want to go, and if you want to make that argument. But I don't think it's worth our time to go back and try and get legislative understanding of what they did, because my experience with many legislative staff is they think they understand it right. Your point is that they understand it. Oh, that should be obvious. And that may be wrong, but I think it'd be better for us to set a regulation, see how it works. Because the other thing is we're going to have to see how in this election season, how are they going to do this? What are they going to do? What kind of case do we get? And that may be the basis for when we go back to the legislature. So I think I'm open to be convinced and go with, I think we need to adopt some regulations in August and do the best we can. And, if there's, and we can even, if we want to say, I'm willing to go to say authentic is not, I can be convinced that authentic is ambiguous in this context.
Let's look at this example. So we have the example I laid out with you just have an ad with this building, which appears to be real, right? So we'd say it meets the authentic standard. So, and this text was placed in by AI, right? So that would, if we go with the approach of I don't know how you would describe it, narrow, strict, basically your interpretation of authentic, right? A disclaimer would be required. But they could still create under the tests that are laid out in the statute, and we're proposing the regulation. the publisher of this could use AI to create that image, right? That's authentic, put it in this mailer, and instead of asking the AI to create the language that says Jess Goldini, they can just put it in with Photoshop and then the disclaimer is not required.
Right.
So it almost seems like we're playing games with the public. They're not going to be able to understand what this actually means. So if we wanted to explain it to the public, it's going to be very difficult. We're going to have to essentially walk through various different tests that we've created to a certain extent. And at the end, I don't think an unsophisticated party is going to really understand what they're seeing.
Right.
And that's my concern. With that said, statutory, if we don't have the authority, we don't have the authority. So, I absolutely,
Okay.
Respect that perspective. As far as what General Counsel Bainbridge's request was, so to get feedback on where we're at in terms of whether we believe a disclaimer is appropriate, not necessarily making the legal interpretation as to whether we have the authority or not. For me, I would say that a disclaimer should not be required where, a photo is merely authentic, right? So I would not require a disclaimer if you take out Miss Goldini and there's just a picture of the Capitol with her name and legislature, just like we have here. With that said, I'm one commissioner on the
Okay.
commission. That's my
So
perspective.
this one, because it's not entirely AI, will not fall into any disclosure.
Will not trigger a disclaimer.
Enclosure. I think that's what we need to understand. So then the substantial alteration kicks in.
Yes.
Yes, if it has some AI intervention, some like the background. And so then we look and said, is that a substantial alteration that will make a reasonable person believe that is the real thing? Is that
Yes.
what would happen?
Yes, and we can
Okay.
look,
And so going back to the actual policy, what Commissioner Brown was saying, that the policy should say on its entirely constructed by AI. Is that what you were saying? Is that because General Counsel wants direction as to what to go?
Yeah, so there's those two tests.
Yeah,
So if it's entirely created with AI, if this ad was entirely created with AI,
yeah,
let's say
out,
they
and then
uploaded a
that
picture
out.
of her.
Oh,
in there. So
yeah.
this entire thing is
Yeah.
created with AI.
This is
And
partially,
if it looks authentic, then a disclaimer is required. Right?
Okay.
So if this was entirely created with AI, it appears authentic to me, as that term is generally understood, right? That's gonna require a disclaimer.
Okay.
However, here, what Council Norton is saying is that this whole background, this whole photo here was created with AI, but this photo of her is real.
Yeah.
Right, so it's materially altered, so we apply a different,
okay,
test.
because it was partially created by AI.
Essentially, correct.
And then we go into the next text, substantially alter a person's perception about that thing.
Yeah.
And then what is substantial? In a situation like this.
Council Bainbridge? No, I thought you wanted to jump.
What
The
is
standard is
substance?
fundamental different understanding is the standard that we're
Yes.
looking at when you are materially altering.
Yeah, but.
So that's the term we're focused on and we're trying to define in our proposed regulation.
So material alter is a substantial alteration? Is that what you're saying?
No, no, I think the key words are fundamentally different understanding of the altered media. So I think if it gives you a fundamentally different understanding, it's been substantially altered. So I think the two
Yes.
kind of are rolled into one. So I think the standard you really want to think about is in looking at this, do I have a fundamentally different understanding of what this ad is trying to portray because AI was used? And our analysis is this, if you look at this ad, what is it trying to tell me? It's trying to tell me this woman is running for office. I
Yeah.
don't think it's trying to communicate anything else. So in that circumstance, I don't have a fundamentally different understanding of what I'm seeing because a Capitol building has been added in the background. And that is how we are interpreting the existing statute and looking to see if the commissioners are in agreement with that.
Okay.
Commissioner Wilson?
I think the way the council, Bainbridge just outlined it, I think is right on point in terms of meeting whatever timeline we need to meet for, the staff, we should obviously move in that direction. Fundamentally different understanding of the ad. I think if you had, for example, the governor standing next to the Jess Goldoni, then that would change the dynamics unless the governor was endorsing her.
Endorsing, yeah.
But let's say the governor wasn't, then that would clearly be a different understanding of the ad.
And I think in either case, that would go to portraying an event that didn't happen if we're adding the governor standing next to her as if they're friends or endorsing, or even, suppose even if the governor had endorsed her, if he weren't actually standing with her, we would say that that portrays something that did not happen and that would require disclosure.
So it would require disclosure
Right.
regardless of whether the governor endorsed.
Right.
Yeah, okay.
Yes.
But if there's something in there that somebody talked about satire. So if somebody wants to have Jess ridicule her, Jess, and that's some funny things in it, then we get into ridicule versus satire.
I don't think that's contemplated under the statute, honestly. I
Okay,
think
yeah,
that might-
well, but satire is exempted.
No,
I thought it was satire, then doesn't call,
that's under a whole different
okay.
statute. So this doesn't touch on satire, and I think because we're in the realm of political ads, that there could be an attack ad, it could portray something that did not occur, but it might not qualify as satire. So that might not even be a relevant analysis.
So in the regulation, we're defining the standard that General Counsel Bainbridge just laid out, correct? So he laid out the fundamentally different understanding of altered media.
That's correct.
Standard.
Yes.
Okay, so this is not a presumption, this is our definition. We're saying that
Yes.
it's going to be met under 18450.12, so 12, subdivision B. So that standard is going to be met when the altered media depicts an individual saying or doing something the individual did not say or do, or contains a realistic depiction of something that did not occur.
Yes.
Okay, so we don't have to make that broader determination. The Enforcement Division doesn't have to make that broader determination of whether something creates a fundamentally different understanding of altered media. They need to make a determination as to these specific circumstances that we're enumerating in the regulation.
Yes,
Correct.
that's correct.
Okay, and that's why, I really appreciate the approach that Legal Division took with this, because I think that makes it much easier for the regulated community and for enforcement, frankly, to be able to enforce these rules, because people are going to know you're going to trigger that disclaimer if your ad depicts an individual saying or doing something the individual did not say or do, or contains a realistic depiction of something that did not occur. I think that's very clear as to the second prong. And the
Yes.
first prong is, where we're having some discussion, and we'll see where Legal Division goes with that particular issue. Any other comments, questions from commissioners?
No.
I think it would still be helpful for you to continue walking through your
It is.
examples. Mr.
I think your comment segues into our next example very nicely. So here we have what we're presuming is a genuine image. This is a candidate running for office in another state. It's a campaign event. I don't know if it's on the steps of a state house, public building, something. She's surrounded by supporters holding signs endorsing her candidacy. So just if we were looking at
That's pretty clear.
the threshold here, is this a qualified political advertisement? For purposes of our analysis, we're going to say it is not. We're assuming it doesn't contain anything altered with AI. It's just a photograph of the campaign event. So if this were used in an ad, there would be no issue concerning AI disclosure. But let's look at the advertisement version. So does it contain AI material? Yes, it was altered using AI. It would be a qualified political advertisement. And based on this, it was substantially altered using artificial intelligence because it would cause a fundamentally different understanding, and it contains a realistic depiction of something that did not occur, which is she's surrounded by people holding signs that say no gas stoves. We know that that didn't occur. We just saw the genuine image previously.
And I think we're all on the same page that this would require a disclaimer.
Yes,
Okay.
good. And in this segment, we have a clip from a video ad that it is a qualified political advertisement. It contains, it was not created entirely using AI, but it includes AI material. So let me see if I can play this.
Growing up in Silicon Valley, I learned early on that a creative spark can change the world. I'm Peter Dixon, and I've carried that with me everywhere I've been. It's what brought me to Kenya, where we used youth soccer to combat ethnic violence. After 9/11, I joined the Marine Corps, and I led young men and women in combat in Iraq and Afghanistan. Because of my experience in combating corruption, I was recruited to Hillary Clinton's State Department, where I worked with nonprofits and federales to combat cartel violence in Mexico. Through all of that, I saw that Silicon Valley has an essential role to play in bringing the US government into the 21st century. That sparked an idea to found a cybersecurity company bringing game-changing commercial technology to the US government. That innovation is now modernizing the American military.
Okay, so as we can see, there's a portion of it that is generated using AI as he's walking down the street in his neighborhood, and it sort of shifts to create sort of animated depictions of things he has done in his previous career capacity. I think we would say here that it does not contain a realistic depiction of something that actually occurred, because it's obvious that he's walking down the street through the whole video.
Are you saying that the background, the war and all that, that's what is no? That's a no, the background?
Well, we're saying that's the AI, but we're saying that it doesn't contain a realistic depiction of something that did or
Which
did
is
not occur.
interesting
Yeah.
because a regular campaign can use pictures, videos in the background.
Yes.
So why do we punish AI and not the other
Oh,
ones?
I think in this case, we're not. We're saying he wouldn't need a disclaimer because it's not a realistic depiction.
So we're gonna do that to regular campaigns?
So we would not need a disclaimer because
Yes.
it was almost like a cartoonish.
It is cartoonish,
image?
yeah.
Okay. What's our feeling as far as whether it's a realistic depiction? Let's say it wasn't cartoonish and they did an AI generated video of him, walking through Iraq when he was in the armed services. I assume we would say, if he said as a candidate, well, I really did that. I really walked through Iraq as a member of the armed services. So why is this a realistic depiction of something that did not occur?
Well, he's walking down the street. So I think if he
Live?
if he produced video, he said, I served in Iraq and here's video. Well, I think if it's a realistic depiction of something that, even if it did occur, it's clearly AI generated. I think there's some context there that if he's walking down the street and it suddenly morphs into something that's more realistic.
This is a thin line for me.
I agree,
is.
and
It is.
I'm just pointing out some potential issues we could run into in the future. I think is a really complicated issue, and I wouldn't expect for us to have this ready to go at pre-notice. So I'd just say that you've done an excellent job. Legal Division's done an excellent job putting together the regulation, the amendments to the record keeping regulation, and I'm looking forward to hearing from the regulated community. And good government groups and other stakeholders as to what their opinions are, arguments. And also, I'm interested in seeing whether this is something we want to address through legislation, potentially. So would it be helpful if, we give you an idea of whether we think that video should include a disclaimer?
I think so, yes.
Okay.
Yeah, I don't have any problem with that video.
Commissioner Wilson?
Yeah, I mean, I would agree with council on this one. If you watch it, it's real clear what it depicts. I also think it's important that we, to the extent feasible, move so that we can make sure we meet per Council Bainbridge's request that we get this resolved as quickly as possible so we can make sure we meet any deadlines to get a regulation in place, as long as we're all in this general agreement.
Yes.
Can I add something?
Sure, Commissioner Ortiz.
And I think it was you, the one who raised the issue. If this candidate was in Iraq, whatever it was, truly, so he's just having the background support his experience, what is that? And no.
Well, I don't think, we're not really arbiters of truth under this statutory regulatory scheme. We're just looking at what's being depicted. So if it did provide a realistic depiction, I think it wouldn't be a defense that he actually was in Iraq, it's that it's using AI-generated video of something. There's no video of it, but he decides to make it and use it in a commercial. I think that would
That's
require
the
a disclaimer.
difficulty of this,
Yeah.
what we're working on.
But I think in
Those
that
lines.
sense, maybe it's not difficult, because if he's passing off supposed footage of, a combat mission, and it turns out, well, it isn't, it's AI generated, it wouldn't be then a defense to say, well, I actually did serve overseas. This is a real thing, so.
Commissioner Brandt?
I'm good. I mean, I think we've had a fruitful discussion, and I support Commissioner Wilson's comment. Let's get this done.
Yeah.
And although I would say that I'm not sure we should be talking about legislation this year for next year even.
Right.
Because I think we need to see how this plays out in this election season and see what kind of complaints we get, see what happens, and we'll learn something. But I think, and that's why I want to reaffirm Commissioner Wilson's comment, let's get something done. Let's see how it gets implemented. But that's why I also think between now and when we adopt it, we need to hear from the regulated community. And they will presumably have watched all this discussion and well, at least hopefully some of them have. And to be able to, what is going to work here? And we're going to start. And so maybe some of these things, like I said, maybe some of the things, if it's completely created, maybe you don't want to do that. We'll leave it to them, but I want to hear from them and I want to get this done before the election season.
Agreed.
So this is going to impact November 2026? If we
Yeah, this
approve
is interpreting a statute that's already in place.
Statute is already in effect, so they already have to comply with it. We're just helping them.
Right.
Okay, so that's what I mean with this policy. Yeah, it will be interesting.
Yeah.
With all
Commissioner
the AI
Brandt,
that-
what are your feelings on essentially doing an IP meeting in the form of a law and policy meeting sometime before August? So we
I-
can give
I think that'd be a good idea.
I think so too. Okay.
And encouraging those who participate to watch this meeting.
Yeah. Okay. I think we've had a good discussion here. Is there any other direction that you'd like from the commission before we move on?
No, I don't think so.
Okay. Do we have any public comment on this item? Okay. Hearing and seeing none. Commissioner Wilson, did you have something to add?
This is more of a question, and I don't know, based on past practices, whether Executive Director West and the chair would think this is a good or bad idea. But I think, your presentation today, I think, was very informative. And using our website, would it be practical to say, okay, we're going to just I know people can go on YouTube and watch our hearings, and I'm assuming that there are many people that do that. But for those who don't, is there a way to just take this presentation, because it is so time sensitive, and making it available on the website so that if anyone from the regulated
Yep.
community wanted to say, okay, what did they talk about at the last FEPC hearing? And I don't want to watch the whole hearing.
Yes.
I just want to see the presentation on this particular AI issue in terms of artificial intelligence disclosure. Is that even?
I believe that is, and I think if we're going to hear this in law and policy, that might be helpful to make that available. But IT has the file.
Yeah, we'll post this to the agenda, so it'll be underneath the item.
I think it's very important.
That's a good idea. Thanks.
Yeah, and just to update those who are watching, it is already posted on our agenda. So you would just go to our website and look at the May 2026 agenda under commission hearings under about FPPC. I believe you can also, if you're just interested in this aspect of the meeting, you can also skip to this part of the meeting by selecting this item.
Yes.
Any additional public comment? Hearing and seeing none, why don't we move on to our next item? Thank you, Mr. Norton.
Thank
Mr.
you.
Bainbridge, Ms. West. And the next item is going to be item number 10, pre-notice discussion of proposed adoption of regulation 18420.5, permitting combined campaign reports. We're going to have here presenting to us Senior Commission Counsel Jenna Reinhardt. Morning, Ms. Reinhardt.
Alrighty. Good morning. My name is Jenna Reinhardt, Senior Commission Counsel with the Legal Division. I'm presenting proposed regulation 18420.5 involving combined campaign reports for pre-notice discussion today, and we will come back at the August Commission meeting for adoption. Some background. Section 84205 of the Act provides that the Commission may, by regulation or written advice, permit candidates and committees to combine campaign reports when filing is required by the Act. The Commission does not currently have a regulation permitting the filing of combined campaign reports. However, since 1985, Commission staff have allowed the filing of combined campaign reports through formal written advice. Staff has identified that many state and local elections result in reporting periods that either overlap or result in a campaign report for a later reporting period being due prior to a campaign report that covers an earlier reporting period. An example of this is seen in the filing schedule provided with the attached Miller advice letter. Under these circumstances, staff has determined that it makes sense and is more convenient for committees to file a combined campaign report, combining the relevant reporting periods into one report. Legal Division staff identified the need for this proposed regulation to make the process more efficient. The current process generally consists of a local filing officer submitting a request for an approved filing schedule for combined campaign reports when they identify that their election date may result in overlapping reporting periods or a campaign report for a later period being due prior to a report covering an earlier period. In response to this type of request, Legal Division staff will draft and issue a formal written advice letter permitting candidates and committees involved in that election to file a combined campaign report as long as it would not reduce or delay disclosure. In addition to the formal advice letter, Legal Division staff also prepares a filing schedule for the relevant election, which includes the option for filing a combined campaign report, and provides that schedule to the filing officer. The proposed regulation will require staff to follow the same process currently being used, except it will remove the requirement for a formal written advice letter, thereby streamlining the process and making it more efficient. Additionally, the proposed regulation will require staff to post each filing schedule created pursuant to this regulation on its website, and the regulation will also require staff to provide notice and a copy of the filing schedule for combined campaign reports to the filing officer of the jurisdiction holding the election. And rather than requiring approval from the Commission to permit the filing of a combined campaign report or to issue a filing schedule, which includes the option for a combined campaign report, under the proposed regulation, this authority is delegated to the Commission's Executive Director. And that is proposed regulation 18420.5 in a nutshell. Please let me know if you have any questions or direction.
Thank you.
Thank you.
Commissioners, any questions or comments? Any public comment on this? All I have to say is I think this is an excellent regulation that addresses probably not the the most exciting aspect of the act. It can be considered mundane, but it's incredibly important. And I think you've done an excellent job laying out why it's so important and why we need to make this change. So thank you so much for your hard work on this, Commissioner Wilson.
Yeah, and this is more of a general question. Excellent, presentation, and it's very informative. And without getting into any specifics or sensitive topics, has this been looked at in the past in terms of, combined campaign reports?
We have had one regulation in the past,
Right.
A former 18420.5. It was, the regulation was created just for one election, and it only considered the February 2008 election, and then the regulation was repealed after the election
Well,
passed.
this is a great idea and provide more efficiency at all levels, so thank you.
Excellent. Do we have any public comment? Sounds like we do not have any. So we're going to move on to our next item. Thank you. We're going to move on to our legislative update with Senior FPPC Legislative Counsel Lindsay Nakano. Welcome, Ms. Nakano. So I was told by Politico this morning that it's a very busy day today.
Yes, it is
A
suspense
lot going on in the
day.
legislature and in Sacramento in general.
Yes,
I hope you're doing well.
I'm good. Okay, good morning, Mr. Chair, Commissioners. There are 18 PRA bills, including 10 FPPC-sponsored bills. I'll update the Commission on the status of those bills and amendments that have occurred. Regarding positions, I'll flag that author's staff have reached out to request that the Commission consider supporting AB 1560, which imposes a restriction on who may serve as a lobbyist. I'll go over that bill more later on. Just wanted to give you a heads up that's coming. I'll also be recommending support for SB 1432. That's the Senate Elections Committee bill, which was amended to now include a couple minor changes that were recommended by FPPC staff. And as alluded to, today is suspense hearing day. The Senate suspense hearing is underway, but they have not yet gotten to any PRA bills, and the Assembly suspense hearing, last time I checked, has not started yet, so we won't have those results for today's update. So I'll move on now to updates to sponsored bills. The first one I have an update on is AB 1736. This extends the existing prohibition that applies to lobbyists and lobbying firms to additionally apply to lobbyist employers relating to what's the practice sometimes referred to as astroturfing. That bill passed in the Assembly 74-0. AB 1788 relating to enhanced disclosure for nonprofit organizations that pay for elected official travel. That is one of the bills that's on suspense today. At the request of the Assembly Elections Committee, we are developing amendments to exempt from these enhanced disclosure requirements organizations including NCSL and CSG, as those were not organizations that were originally contemplated to have been included in this reporting requirement.
And perhaps for the benefit of the public, we should say what that acronym, what those two acronyms refer to.
National Conference on State Legislatures and the Council on State Governments. Is that right?
I believe so.
Okay. Thank you. Okay, moving on to AB 1789. This bill imposes a new campaign training requirement for certain candidates and treasurers. That bill is also on suspense. There were a few amendments made requested by the Assembly Elections Committee. Those include changing the consequence for not completing the training on time. Instead of prohibiting the candidate from being printed on the ballot if they fail to take the training on time, the bill would prohibit the candidate from receiving additional contributions until the candidate completes the training. Additionally, the amendments exempt from the training requirements candidates who indicate on their statement of intention that they don't intend to qualify as a committee by raising $2,000 or more in contributions. And the bill was amended to limit the training duration to 90 minutes for candidates and 120 minutes for treasurers. AB 2255, which imposes enhanced disclosure for large expenditures in years that a candidate will not be on the ballot. That bill's on the Assembly floor. There were amendments made to the bill to fill in a blank, which was the threshold amount for the additional reporting, and that was filled into $20,000. So the additional reporting would be required if the committee makes an expenditure to a single person totaling $20,000 or more in the aggregate during the reporting period. AB 2421, which enables the Secretary of State's office to automatically terminate inactive committees under certain circumstances. That bill is on the Assembly floor. It was amended to clarify that the Secretary of State has authority to terminate inactive committees under the bill, rather than creating a requirement that they must terminate inactive committees under the bill. AB 2592, which transfers the lobbyist training requirement from the Legislative Ethics Committees to the Commission, is on suspense. There were amendments made that clarify that the Legislative Ethics Committees have final approval over the content of the course that relates to the legislature's policies against harassment. AB 2655, this is the bill that requires any security personnel paid for using campaign funds to be appropriately licensed. That bill passed in the Assembly 6620. And the last bill, last sponsored bill I have an update on is SB 1389. This expands the time period for waiving the $10 per day late fee for late Form 700s. That bill passed in the Senate 3620. It was amended as requested by the Senate Elections Committee to clarify how the fine is calculated. And those amendments were intended to clarify, not change that portion of the statute. I'll pause here for any questions or comments before I move on to updates on other PRA bills.
You can go ahead, Ms. Nagano.
Okay, thank you. Okay, first bill, AB 1560 by Assemblymember Tangipa. This bill is currently on the Assembly floor. As I mentioned earlier, the author has asked the Commission to consider supporting this bill. I'll go over a summary of it since that request has been made. AB 1560 would prohibit a person from acting as a lobbyist if the person has been convicted of a crime of public corruption, and that is defined to mean a felony involving accepting or giving or offering to give any bribe, the embezzlement of public money, extortion or theft of public money, perjury, or conspiracy to commit any of those crimes. The bill would require a statement on the lobbyist certification filed with SOS that the lobbyist has not been convicted of such a crime, and would prohibit SOS from accepting a lobbyist certification if the lobbyist has a relevant conviction. And the prohibitions in the bill extend 12 years from the date of conviction. We have requested amendments to clarify that SOS may take the lobbyist's statement on their certification at face value, that they don't have one of those relevant convictions, so that SOS is not liable for checking each lobbyist certification and any relevant convictions for each lobbyist that registers. I'll pause here for any questions or discussion.
Yeah, so ultimately, what is our responsibility? What is our duty under this proposed legislation? Are we going to have to enforce this rule?
Yes, since it's in the PRA, the Commission would be responsible for enforcing any violations. So if a lobbyist does register, if they do not check the box that says they have a conviction and they register as a lobbyist and act as a lobbyist, they would be in violation, and the Commission would be responsible for enforcing.
That's helpful. I'd say, since the author is asking for our support, before I'd be willing to support it, I want to better understand what sort of resources we have and what sort of resources we're going to need in order to enforce this law. Right? I don't know if we have access to the sorts of law enforcement databases that peace officers do for us to be able to determine whether somebody has this sort of background that would be a violation of this rule. But I'm interested to hear what other commissioners have to say, if anything, on the topic.
Well, and if
Commissioner
there's
Brand?
any, yeah, I think if we're going to go down that track, then I think that the other question is, what is the enforcement? What are the enforcement authorities, and how does that work? What do you expect us to do? And is it enough that we just say, okay, he violated the statute, we're done? So that's the question about what is it? You're barring it now. What do you expect us to do for enforcement? And I think your questions are right on point.
Excellent, thank you.
Yeah.
Commissioner
Yeah,
Wilson?
I think, Commissioner Brand and the chair made an excellent point, and I have to admit I didn't read the bill. I just read your excellent analysis. Would it include any conviction for public corruption, even if it was in another jurisdiction? So if you lived in Maine and 20 years ago, when I was young, I just did a little political corruption and I cut a deal. But now that I'm in my 60s and I'm lobbying, California, would that conviction from another state apply? And I'm assuming it would, but I just wanted to clarify that.
A related question, you mentioned if it was a long time ago. It only applies 12 years from the date of the
Oh, I didn't know.
conviction.
12.
But let me see if it might be specific to California law. Let me check that right.
You don't have to take the time to do that now. That's just a technical question.
I have a quick answer. Felony in this state and under the laws of any other state or the
Oh,
United States or foreign government. So it's pretty broad.
Okay, thank you.
Is that enough, feedback, you believe, for the author's office?
Yes, we'll reach out with that feedback I'll return with information about enforcement.
Excellent. Thank you, Ms. Nakano.
Okay, moving on. AB 1840, this bill included a prohibition on using non-public information related to prediction market contracts. That bill was set for hearing in the Assembly Elections Committee, but was pulled, the hearing canceled at the request of the author. So it appears that bill will not be moving forward this year. AB 2413, which prohibits public funds from being used to pay for large format public advertisements that include the photograph of an elected official, passed in the Assembly 71-0. The bill was amended per the Commission's request to clarify the dimensions of a large format advertisement, and with that amendment, the Commission is in support. SB 900 makes several changes to the advertisement disclaimer requirements, and that bill is on suspense in the Assembly. SB 1159, this bill amends the PRA to provide that the terms person, interested person, participant, member of the public, and similar terms referring to those who may engage with the Commission and other agencies do not include artificial intelligence systems, autonomous agents, robots, or other non-human entities, whether physical or digital. And this is part of a larger bill that applies those same exclusions to other acts, including CPRA, the California Public Records Act, and others. That bill passed in the Senate 38-0. We have requested amendments to clarify that the bill does not inadvertently alter the definition of person under the Act to exempt things like organizations or committees or business entities. SB 1175, this bill permits lobbyists to file amended lobby certifications and registrations and notices of termination directly with the SOS. That bill passed in the Senate 36-0. SB 1225, which transfers the duty to prepare ballot summaries and titles from the Attorney General to the Legislative Analyst's Office. That bill is on suspense. And last, SB 1432. This is the Senate Elections Committee bill. It includes a handful of proposals that make minor changes or corrections in the Political Reform Act. The bill passed in the Senate 36-0. The bill was amended to include a few minor proposals recommended by FPPC staff, including a couple corrections, as well as a change to a provision relating to civil service classifications for the agency. And given that the bill was amended to include those recommendations from staff, I would recommend that the Commission support this bill. Pause here for any questions or discussion.
Would you like us to, is the request from the author for us to make a motion to support?
I have not received a direct request. However, given that they have included proposals that we requested, I would encourage the Commission to consider support.
Okay. Personally, I would move to support. Ms. Vo? Oh, before we do that, public comment on this particular item?
None.
Hearing and seeing none. Ms. Vo?
Commissioner Brandt,
Aye.
Commissioner Ortiz, Commissioner Wilson,
Aye.
Chair Silver.
Aye.
Motion passes.
Thank you.
Excellent. Thank you, Ms. Nakano.
Thank you. And that concludes my update, but happy to take any questions.
Any public comment generally, Ms. Vo, on the legislative update? Okay. Any other questions, comments from commissioners? No? Okay, great. Thank you, Ms. Nakano.
Thank you.
Let's move on to item number 12, our executive staff reports. We're going to start with our enforcement chief, Kendall Bonebreak.
Good morning
morning.
again. The Enforcement Division report is as submitted, but I'm happy to answer any questions anyone may have.
Excellent. Any questions or comments for Enforcement Chief Bonebrake? No.
Okay.
Thank you.
Thank you.
Let's move on to our Audits and Assistance Division. Chief of Audits and Assistance, Sharada Shah. Good morning, Ms. Shah.
Good morning. My report is also as submitted, but happy to answer any questions.
Excellent. I don't have any questions on that report, commissioners. No?
Thank you.
Thank you, Ms. Shaw. Let's move on to the Legal Division, General Counsel Bainbridge.
Yeah, I got some stuff to say.
Okay, let's do it.
Just wanted to highlight that our prep division launched a new course since our last meeting. It's the advertisement course for candidates and candidate control committees, and we've even had one person complete it already. So another option for the prep program. And then I also wanted to mention our pre-election outreach program for the newer commissioners. This is something we do before the primary and general elections, where we reach out to county and city filing officials and ask them to send us a list of their candidates who have not filed yet once they miss the pre-election deadline. We then, the prep group then reaches out to them, makes contact, informs them of their filing requirements, and does whatever they can to get them to file their late statement. So we've done this for the first pre-election, which was due a few weeks ago. We received 81 referrals from the local filing officials, and we were able to get 75 of them to file and be in compliance with the filing requirements. So 93% of the ones who hadn't filed have now filed. The other 6 have gone to enforcement they're out of the education phase of the non-filing part. So just wanted to highlight this is a program that we've had for a few years now, and you can see how efficient it is at getting people to file who haven't filed yet.
Well, I appreciate you highlighting that for the public. That's tremendously important that the public is getting access to this information when it matters most before the election. So thank you. Any questions, comments from commissioners on Legal Division? Exec staff report? No? Okay. Thank you, Mr. Bainbridge. Let's move on to our next executive staff report, which is our Administration Technology Division, Chief Administration, Dr. Ju Wang. Good morning.
Good morning. I'm a report submitted as it is. I'm happy to answer all the questions you have.
Okay, and we received an update on our budget, or we received a expense report.
Correct.
From you all in your division this month, so I just wanted to point that out for commissioners to see if they had any feedback on that. If not, I don't have any additional comment on your report or the executive staff report as a whole. Commissioner Wilson?
So and this is more of a technical question. Thanks for the detailed report. And this is just more for the benefit of, for the public, I guess. When it comes to late filings, is there a particular reason that, for example, constitutional officers or even members of the judicial branch file late? Is there a pattern without getting into specific names, obviously?
So as of today, we still have the 3 retired judge haven't filed the March 2nd deadline.
Okay.
So the retired judge, that could be multiple reason. So in general wise, we have a lot of late filing. So what we could do the next year, we're definitely going to work with education to make everybody awareness. And a lot of filer and got a lot the notification. They didn't really make aware I need to file as soon as possible. They always wait to the last minute, and there's all the different scenario that cause all the late.
Yeah, well, maybe I'm biased, but I think from what I can tell since I've been on the commission, the FPPC has been very proactive in making sure that elected officials, staff, et cetera, receive notification of the deadlines.
Yes.
And
what we did. And
when you have elected officials that have staff, then they have an additional layer of resources to make sure that these deadlines are met, so.
Definitely,
Okay, all
definitely.
right.
But it's getting there. Hopefully next year it's better. Every day's better.
Okay, well,
Thank you.
that's an optimistic approach, thank you.
And kind of building on Commissioner Wilson's comment, I think it'd be helpful for us to take a look at the late filings from this most recent annual period and see whether any sort of additional background or comments were provided by the late filers as to why they didn't file on time. I think where you might find that info would be at the very end of the electronic filing where they're requesting that we, waive their fine. They're likely going to say, maybe the FPPC or their filing officer had the wrong email, or I just forgot about it. Who knows? But at the end of the day, we do want to know. To the extent that
Yes.
we do have that information, I think it'd be great to present it to the commission.
That's good idea. And I just want to point out, so if you look at the chart, compare the last year, we do increase like 40% for the 2025 annual statement because the new for the SBA 52, we received all the statement for the public official who manage public investment. So our statements dramatically increase. So that's why we still have around 1,000 non-filer. I'm not saying 1,000 non-filer, 1,000 not filing statements. So the non-filer probably around half, like 600, 700. But this is the first year for all the SBA 52 filer file with FPPC. So we try to work with the filing officer, try to get them board as soon as possible.
Yeah, so just to clarify for the public, what you're laying out here is we have 1,000 or so more filers than we did in previous years because of a change in the law that requires us to be the filing officer official for public officials who manage public investment. Right, is that correct? And
So-
that may be why
As
we're
of-
seeing the level of non-filing or late filing.
As of May 1st, so we have 5,810 SBA 52 filer has been added to the system.
Okay, so it's 5,000.
5,000. So compare the non-filer, so we have like 1,210, but this is not non-filer. I would just say it's not non-filing statement. Yeah, so some filers sitting in the multiple position. So if just talking about non-filer, the number will be definitely going to be decreased.
Okay, that's helpful.
Mhm.
Any other questions on this report? Excellent. Any public comment? No? Okay. Thank you, Dr. Wang. Okay, Executive Director West.
Hello, everyone. I just wanted to bring something to your attention. If you look at item number 6 in our agenda and item number 10, you'll see that item number 6 was staffed by Kevin Cornwall, who is in the Enforcement Division, and item 10 was Jenna Reinhardt, who is in the Legal Division. They're part of a program we started to help people cross-train. So they were originally in the opposite divisions, and they have been working in legal or enforcement and doing a great job. As you can see, they're on the agendas and producing good work, getting some good experience. Part of this program we're trying to institute to get everybody to learn all the different functions under that agency. So just wanted to point that out, and I'm happy it's going well. Nobody was screaming or crying when they had to present their items, so I think we're all good. That's the indicator.
It's a low bar, Ms. West. Okay, excellent. Well, thank you for that update. Why don't we move on to item number 13, Commissioner comments and proposed future agenda items. The only thing I would add, and this relates to item number 9 that we were talking about earlier related to the AI disclaimer requirements. I'd like to better understand, since we didn't get to touch on the record keeping aspect of that item, what burden, if any, that's going to place on political actors, so candidates, committees. I'm particularly concerned about, smaller campaigns, those folks who cannot afford to hire attorneys or other compliance staff. But it'd be helpful to understand, that aspect of it for all participants in that arena. Any other items that commissioners would like to add? No? Okay, perfect. Then I'm going to move to adjourn. Okay, Ms. Vo?
Commissioner Brandt?
Aye.
Commissioner Ortiz?
Yes.
Commissioner Wilson?
Aye.
Chair Silver?
Aye.
Meeting adjourned.
Thank you.